compatible with our climate, our economy, and our desire for the environment that we prize so highly in the state. I can understand that point of view. I have never advocated that, and I'm not advocating that now. And if one looks at LD 750 as a de facto ban on mining, which I do not, but if one does look at it that way, I think it raises a really serious question, which is what aspect of this serves to make it a de facto ban, and is that really saying that the industry is incapable of mining without environmental destruction and taxpayer costs?
Hold that thought for a second, Ralph. It's just I forgot to warn you, though, if your phone goes off, you owe us $5, so go ahead. And if the State Representative Levy will, I have a couple other questions, then come back to you. So finish your answer.
That must be Providence speaking. Sorry about that.
It's okay. Just collect the $5, you'll be all set. All right, well, from now on,
I could collect my song.
The first one's free.
the first one is free. It's been used up.
If one looks at my bill as a de facto ban on mining, to me that would mean that someone is of the opinion that the mining industry is incapable of operating a sulfide mine without polluting the environment at cost to the taxpayer. If that were the case, then it would be a ban on mining. I do not believe that's the case. I cannot point to good evidence, but that's not the case. But I have the sense that the mining industry, like many human endeavors, have those players that apply expertise and humanity and conduct themselves in a responsible fashion. And there are those players that try to cut as many corners as possible and may not operate as ethically or legally or with a high degree of responsibility. And so I think that LD 750, unlike any rules proposed in 1969, in the 80s, 1991, or rejected in the last session, none of those rules seem to me to fit the actual problems that metal mining could create. I've tried to refocus LD 750 to address what I think the substantive problems are. I believe the industry can rise to the level of responsibility that LD 750 would require. Thank you for that question.
We'll come back to it. Sure. Representative Duchesne. And Senator Breen, you have a question? No.
Thank you, Senator. Actually, this is just for work session. If you could flag for us or flag for me where current statute and proposed rules are just too weak, and especially flag what's in LD 750 that isn't in statute or rule, so I can compare the two. I think I could see some of the things that's in your statute that aren't in the rules, but I'm not sure I'm capturing them all. So we can talk about that at some point. That'd be good. And the other thing is, if we did apply LD 750 and put that into statute, what would change in the rulemaking result once we send that back to the DEP and BEP? If you can sort of capture some of that for me, we can talk about it.
Other questions? I have a couple. No, she's still said. In your testimony, you talk about past records of the applicants, and in the spirit of what Representative Duchesne, I would ask you to look at 8G in the application process, where it talks about the applicant and all their past consent decrees and so forth, and see if that doesn't solve your issue. And the second question is, have you looked at Jamie Kilbrick's suggestion to us? He came in here invited by, I believe, some of the environmental groups on third party on financial assurance, and has rewritten that for us, which I think we're leaning towards adopting, to see if that goes that way. Also, a third thing is you give us a quote, and just a personal thing, I don't like out of context quotes, so just nothing to say that was said before, but I'd like the complete quote that you used, that was there, not just a piece of it, so that I have the context of what that came from. That would be helpful. And you cite the 1990s report. Do you know of an update? Perhaps you can get a copy of that for us so that we have that to look at too. And my last question is, do you know if any taxpayer money were paid at the Kerr-Rands mine site?
Not yet.
But have they? I didn't ask them.
I said not yet.
My question was, has any to date been paid? The answer is no. And also, can you also look into, and I don't want to get into it, but why Callahan Mine is presently on that list, and why the state is in fact responsible for some of it?
You'd like that information for the work session? You want me to give you a quick answer?
It's fine. Other questions?
In response to when I said not yet on the American Mine, the DEP, to my knowledge, has not yet released a report on the monitoring of the effluent from the mine area since the geosynthetic cover was put on. So it's not yet known whether the cover is working. If it's not working, I know that there are no additional assets available to replace it, for instance. If it is working, then taxpayers may not have any substantial costs until time for its replacement.
Thank you for the clarification. Other questions? No? Oh, yeah, I'm sorry. Senator Green?
Go ahead. No. I was going to. Thank you, Mr. Chair.
Yes.
I just want to be sure that I'm hearing you correctly, because I think it's an important point, because you and I talked about this topic offline about, come on, aren't you really in favor of a ban? Maybe the committee should recommend a ban, and maybe I'll turn your bill into a ban, and, we've had the banning discussion. And it sounds to me like your goal, well, let me ask you, is your goal A, to prevent metallic mining in Maine entirely? Or is it B, to prevent environmental damage and protect Maine taxpayers from the cleanup of that potential environmental cleanup?
The answer to A is no, the answer to B is yes. So my intent is not to ban mining. Quite simply, it might be about a one-sentence bill if it were a mining ban bill, and quite frankly, that would be far easier legislatively to proceed. More nearly, I think that this is an example in which if we're going to do it, we should do it right. And what I've been trying to focus on is what constitutes the right way to do this. I know that I'm not an expert in mining. I know that the committee members, the agency personnel, the legislature in general, the government in general is not expert. So my interest is, how do the governmental processes work to bring in the needed expertise to do it right? And I've tried to indicate that the responsibility of this portion of government is to set a framework. The portion of government in the executive branch is to turn that framework into rules, and that we find ways to bring that expertise to bear on the question, so that if it's done in a right way.
Other questions? Representative Harlow? I wanted Bob's Representative Tucker. Thank you very much. You're welcome.
Representative Chapman, it's nice to see you, and it's nice to see someone else named Ralph.
My uncle was named Ralph.
Could you just I understand you have a scientific background, although not in mining. Is that right?
That's correct.
Could you just explain to me the differences here? What is in situ leaching, heap leaching, and block caving? Why are those specifically mentioned in this very general bill?
Right, these are what the industry recognizes as high risk processes. In situ leaching is where you're pumping the chemicals into the ground to dissolve the mineral ores. In a sense, it has that relationship to fracking, of putting something into the ground for the purpose of altering what's underneath, rather than digging in. And in the process, of course, the unknown is where does that leak out? What's the totality of the underground pathways for the water seepage, et cetera, et cetera. So that's the mining industry is not a static industry. It attempts to find ways of mining deposits. Every deposit is unique. That's one that. Let me put this in context. Maine's climate is one which makes mining more problematic because of it being a wet environment, and my mention of the aqueous oxidation process as being the principal difficulty. So it's important that we allow mining processes that are a little less risky rather than more risky. The heap leaching, the block caving, I'd be happy to provide you additional information about those processes at the work session.
Other questions? I do have one, and I want to make sure I'm clear. In the bill, you just talked about third-party independent for financial assurance, correct? And were you also talking about third-party review?
Yeah, thank you for the question. I mentioned third party for financial assurance purposes. I had intended, and I've spoken to the need for third party expertise in a variety of technological areas related to mining. I would prefer to. I'm having difficulty knowing how to legislate the acquisition of good advice. And that's, if I could do that, that's what it would say. It would say, acquire good advice. I'm happy for the committee members' ideas on how to effectively do that as well. That's why I say it's necessary for this to work. It would be necessary to have what I'll call cooperation of the department, which typically is the governmental entity that would be accessing that expertise. And then there's always the question, it's a little bit like the couple that are looking for the a divorce mediator, and one wants one mediator and one wants another. And obviously we can get into those questions here of which expert is the how do we cherry pick the expert that's going to tell us what we want to know? And I think that if we build the structure to encourage the acquisition of good advice, even though it may not work, it's going to do us better than if we don't ask for it.
And I don't disagree. I just would ask you to look at subchapter 4, financial assurance and insurance, section 17A7, where it actually calls for the department to hire not to get approval to, but to hire a third party in the evaluation of financial assurance. I think we have that down. But just want you to suggest that you look at that language if you would. Other questions? Thanks, Ralph. Thanks for keeping smiling through this. Appreciate you coming to us.
Thank you all.
Now, the intent is to go to the department, and then what we'll do is we're going to start with miles away, so that those that have come a long way have the opportunity to get on the road, to get back home, and we will not differentiate between for and against. We'll just take you to come up as you come up. Good to see you, Heather.
Good morning.
Sorry, this is the first time you've talked to us about this, correct?
Never been before, even this committee on this subject, never before. Good morning, Senator Saviello, Representative Welsh, members of the committee. I am Heather Parent. I'm the Deputy Commissioner of the Department of Environmental Protection. I'm speaking today in opposition to LD 750. On February 25th of this year, I stood before this committee and presented a provisionally adopted rule to the Board of Environmental Protection and requested your adoption. That rule was the product of many months of analysis and drafting. In that process of analysis and drafting, we learned a great deal from the regulation of other jurisdictions, both within the United States and outside the United States, and from other operations throughout the country. And we implemented many provisions of the provisionally adopted rules that were in direct response to our understanding of what was happening in other jurisdictions. It really helped us modernize the process from the last time we went through this process in the early 1990s. The rule was provisionally adopted after several additional months of public meetings and hearings held by the board. This was a very useful process, a very public process, and we went through many iterations of understandings before developing what I believe is a very good provisionally adopted rule before you. That provisionally adopted rule followed the requirements of the 2012 framework law that I've discussed with you before this session. For the reasons that I will describe for you today, a moratorium should not be imposed on exploration in metallic mineral mining, and the provisionally adopted rules apply appropriate and environmentally protective standards, and it's unnecessary for the department to reinitiate rulemaking to rewrite rules that have already been developed. I'm going to very briefly discuss the process and then get right into the point by point to address the points of the bill. In 2011, the legislature passed an act to improve environmental oversight and streamline permitting for metallic mineral mining in Maine, which directed the department to amend its mining rules to clarify the application requirements for metallic mineral exploration, advanced exploration activities, and to adopt major substantive rules to modernize Maine's mining requirements and reduce the number of separate environmental permits necessary for mining activities by January 10, 2014. We initiated rulemaking activities to update and amend the exploration and advanced exploration permitting requirements in existing mining rules in 2012. The routine technical rulemaking provided specific application, permitting, performance requirements for individuals to conduct exploration and advanced exploration activities. We completed this rulemaking in March of 2013. The formal rulemaking process for major substantive mining rules began in mid-September. During the October 2017 public hearing, the board heard testimony from a number of consultants, interested parties, and the general public. Additional comments were received during a written comment period. The board held 4 deliberative sessions after that point on the proposal to discuss key issues raised by the commenters with department staff. During the course of that, we also received comments from EPA, both informal and formal, and we implemented changes in the rule to address those comments. Specifically, I'm aware of the Resource Conservation Recovery Act program, which is a delegated program to us, and the Clean Water Act program. We ran some clarification changes by EPA so that they were understanding those changes that were made. At the board's request, we prepared some draft language incorporating many of the board's suggestions. From the deliberative sessions, the board posted those changes for additional written comment period. On January 10th of 2014, the board reviewed a number of changes that were made to the proposal in response to public comments. And after receiving additional oral comments on the proposal pursuant to law, they deliberated and voted to provisionally adopt the proposed rule. The provisionally adopted rule provides for a comprehensive framework for implementing Maine's Metallic Mineral Mining Act and provides for the protection of natural resources, including surface and groundwater, in accordance with statutory requirements. I just wanted to note that we also believe in prevention. We actually learned a lot from regulatory approaches and from other mining experiences throughout the country and other jurisdictions beyond the country, and we actually implemented those into the provisionally adopted rule. What you will find the differences between the existing rules that are in effect today and provisionally adopted rules are a series of early detection and correction measures that will hopefully prevent a mine from ever getting to the point of needing to have large penalties and fines. We also believe that penalties and fines are important and should remain in effect. But we actually believe that both paradigms are important. Early detection, early correction, and holding the mine accountable by continuing to have those fine and fee, those fine provisions in there in the event that something does cause there to be a violation of a law. I will outline for you where in our provisionally adopted rules the items that were listed in this bill are actually already there, and happy to discuss those both today and at subsequent work sessions. The provisionally adopted rule requires that the applicant comply with all applicable federal environmental laws and standards. Section 4 on page 10 of the rules provides a detailed list of these laws. It requires that reclamation activities be undertaken to not only leave or return the property to a geologically stable state, but also reclaim the mining areas and affected area to the ecological conditions and approximate pre-mining conditions. Section 23, starting at page 69 of the rules, detail extensive reclamation standards. The reclamation plan described in section 23 is required as an application submission. This requirement is in section 9I-4 on page 26. The plan must include the plan not only for post-closure remediation, but also for contemporaneous reclamation activities. Again, we're trying to look for early detection and correction as well as contemporaneous reclamation whenever possible. Requirements that the mine plan submission requirements detail the technologies used for the site, and the engineering report requires that an evaluation be conducted for the potential nodes and significance of failures in engineered systems. These portions of the rule are located at section 9I on page 26 and section 9E on page 22 respectively. The provisionally adopted rule requires financial assurance that would be utilized to ensure that the applicant pays for any remediation costs. The application requirement is located on section 9L on page 29, and the details of the financial assurance requirements are located in section 17, starting on page 43 of the rules. Coverage of financial assurance language in section 17B on page 44 states, quote, financial assurance under this section applies to mining and reclamation operations that are subject to a mining permit and must be sufficient for the department to administer all activities necessary for investigation, monitoring, closure, post-closure, treatment, remediation, corrective action, reclamation, operation, and maintenance under the mine plan, and, importantly, implement other necessary environmental protection measures, including remediation of any air, surface, water, or groundwater contamination. The provisionally adopted rule requires that all terms and conditions of financial assurances must be approved by the department and must be analyzed by individuals with documented experience in material handling and construction, mining costs, and financial analysis. The department may hire third parties to perform these evaluations, but in any instance, that analysis must be made with somebody with experience in mining and financial analysis. The provisionally adopted, and that's located on section 17A7 on page 44. The provisionally adopted rules prohibit heap leaching, which in the framework law actually required a prohibition on heap leaching. We actually expanded heap leaching to include percolation leaching, and that requirement of prohibiting heap leaching is located, well, the definition is located in section 2VV on page 5, and prohibition of heap leaching, which includes heap leaching and percolation leaching, is located in the very beginning of the rules. I apologize, it's the one area that I don't have a citation for you this morning. The provisionally adopted rules require that the applicant provide details and in mining experience, including a list of all mines controlled or operated by the applicant, parent companies, subsidiaries, predecessors, or related persons in the United States and abroad. There's no definition of abroad, so we would consider abroad including the contiguous continent. This list must include the compliance record. We look at that record and we make a determination regarding whether or not their proposal would satisfy the requirements. This requirement is located in section 9B5 on page 19 of the provisionally adopted rules. And finally, in addition to requiring the permittee to notify the department of any changes from the plan as they occur, and also of any violations or elevated levels in the monitoring wells as they occur, there's also yearly updates that are required by the permittee to their mining and reclamation report. And so this allows the department to evaluate that on a yearly basis, as we do with a number of different types of sites, and require them to make adjustments and changes accordingly. So that gives us the ability to require things on a contemporaneous basis for elements where they are notifying us of an elevated level of or issue of concern. And it also allows us to do a yearly evaluation to make corrections that might not be associated with a pinpoint issue. That requirement is located in section 26 on page 78. As I've just detailed, the provisionally adopted rules require a myriad of requirements designed to ensure appropriate environmental protection measures, and that's why we feel that a moratorium would not be appropriate at this time. I would note that we do have valid rules that are in place right now. The Chapter 200 rules that are separate from the provisionally adopted rules are valid, and we also have a valid law in place right now, so we are not operating without rules or laws that can be utilized. And I believe the committee has discussed, has had many discussions, and will have more discussions regarding how to address any potential action on the provisionally adopted rules. I do thank you for the opportunity to provide this testimony. I'm available obviously today and at subsequent work sessions to answer your questions.
Representative Martin.
Thank you very much. Thank you for being here today. And I assume you've seen the bill.
Yes.
And I'm under 1G, you've got leaching pretty much dealt with. How about block caving?
We do not have a specific prohibition listed with respect to block caving. That if the committee were to determine in its review of our provisionally adopted rules that you would accept our provisionally adopted rules, but direct us to do something with respect to block caving, I believe that is a discussion that we would be willing to have, and can speak more with folks about that on a work session.
Would you, maybe you might take a look at the DEP, whether or not they discussed it in their...
To my recollection, I don't believe anybody's discussed block caving. Certainly no more than a passing comment that they made about it. So, and I'm not sure that even that has happened. So we'd certainly be willing to entertain that and discuss it more with the committee to determine whether or not that's the best.
For the work session, did you come up perhaps with what that would be and how that should occur?
Yes.
Or not occur?
Yes.
Either way. Thank you.
Representative Harlow, and then Representative Buckland.
Thank you, Mr. Chair. I have two questions. The first is a question that I've heard answered a couple of different ways, so I figured I'd ask you rather than continue to ask other people and hear a couple different answers. So one of the reasons that we're oftentimes given for redoing or making sure that the rules, or that we're working on the rules, is because a mine could be permitted right now, and that the conflict, that there's a conflict between the statute and the rules?
There are many provisions of the existing rules where there is no conflict between the existing rules and statute. And obviously, we would be applying those. To the extent that there are provisions of the statute that do conflict with the existing rules, the statute takes precedent over the rules, and at that point, we would have to apply our judgment as to what the intent of the legislature would be in those circumstances.
So you could permit a mine currently?
That's correct. Of course, for mining activity, we would require 2 years of research, so I don't see that happening anytime soon, but that is correct under the current framework.
And one of my other questions, and I've spoken with Representative DeShane about this, the compliance where you say that the list must include the compliance record. How far back does that compliance record have to go?
It's not stated, so we would be asking for all of their, I don't believe it's specifically stated how far back it goes in our provisionally adopted rules.
Actually, it's 10 years.
Maybe 10 years. It's all right. but keep-
It is stated in our provisionally adopted.
It is,
Okay, there
it's
we
10
go.
years. That was one of the things that I wondered why, whether or not you permit a mine or not. Based on this, I don't know what the answer is to that, but I was just curious as to why you wouldn't want the compliance record of a company for their existence.
I would note that these are application submission requirements, so this is what's necessary to get an application through the door. Even with the most simple of applications that come through the department, we oftentimes ask a lot of follow-up questions that go beyond the basic application requirements. This would not prohibit us from going back further than 10 years, and I dare say that we would be looking to require more than 10 years if there was some sort of flag that was raised for the reviewers of the application department.
I just think that that would probably be important to have all the information rather than just 10 years, and that's all.
Yes.
Representative Tucker? Oh, I'm sorry, Representative Buckland's next, then Representative Tucker.
Thank you, Mr. Chair. I have a sort of a simple question, and Representative Chapman said he was going to get it for the work session, but is there a simple explanation of what block caving is? I understand in situ, I understand heap leaching.
I have a rudimentary understanding, but I don't want to misspeak, so I would rather bring that back to work session and make sure that our mining experts make sure that I do not misspeak on that.
Fair enough.
Representative Tucker?
I'd like to follow up on the answer you gave to Representative Harlow's question about applying the old rules, but then applying the old rules, but also incorporating in that the new the mining statute of 2011. When we come back for a work session, I wonder if you could take another look at LD 1853 and see whether it expressly states that Chapter 200 remains in effect until new mining rules achieve final adoption. That's on Section 31.1.
Correct.
Because it may be that your interpretation may be incorrect under that statute.
But if you look at the next section of the statute, and I apologize, I don't have it in front of me, it also indicates that the effective date of the statute was June of 2014. And so that causes the 2012 statute to be in effect as of June of 2014. But it has the existing Chapter 200 rules remaining in effect until the new provisionally adopted rules are accepted by the legislature.
Precisely. That's what I'd like to have you take another look at.
Other questions? Representative DeShane?
Thank you very much, Senator. Just digging that one a little closer, because that seems to be the nub. The old rule said that groundwater contamination was not allowed at the site of the mine. The new statute says that you can discharge the groundwater, but then there's provisions about how fast you better clean it up. if the new statute says you can have that kind of instant contamination before you have it cleaned up, but the old rules don't.
So you're flipping the reality for the sake of your question, is that what you're saying?
Well, no, I'm probably saying it about as badly as it could be said.
Okay. No,
But
I'm just trying to understand.
The new statute says that contamination can, discharges to groundwater can happen. The old rules don't.
That's correct.
Which is going to govern if someone comes in now, since the new statute also says the old rules are in effect?
The new statute has the point of compliance being no further than, when possible, 100 feet from the area of the mining area, which is a defined term. So that would be what would govern, and then we would obviously make sure that to the extent that that is conflicting with the existing Chapter 200 rules, that governs, and then we apply the intent of the 2012 rules to ensure that we have enough contemporaneous monitoring and other protective provisions in place to achieve the intent of the 2012 statutory provisions. Because that would be a conflict, and so in that case, we would have to look to the intent of the 2012 statutory provisions to ensure that we resolve that conflict.
I have seen legal opinions from all over the map on that one. Has there been legal discussion within the department about how to treat it?
There have certainly been discussions. There's obviously three elements to the framework law and to our rules: exploration, advanced exploration, and the mining itself. Mining, we would have a series of pre-application meetings and a whole bunch of stuff that happens before the pre-application meetings, which haven't been initiated yet. So we've been looking at it, as far as if an application came to us today, how would we do it? Obviously looking at exploration and advanced exploration activities as well.
Senator Green?